In the detailed judgment delivered Wednesday, the majority judges ruled that the election had failed to satisfy the verification requirement in the Constitution. Deputy Chief Justice Philomena Mwilu appearing to take blame right at the door of the returning officer for the presidential election, Wafula Chebukati, the IEBC chairperson.
We are of the view that the contentions by the first and second respondents ignore two important factors. One, that elections are not only about numbers, as many, surprisingly, even prominent lawyers would like the country to believe. Elections are not events, but processes.
The court said the officials of the IEBC had violated the Constitution by generating the final presidential tally from Forms 34B, contrary to the provisions of the law that they be generated from Forms 34A.
At the end of the day, neither the first nor the second respondent has offered any plausible response to the question as to whether all Forms 34A had been electronically transmitted to the NTC as required by Section 39(1)(c) of the Elections Act.
The judgment poking holes into IEBC's decision of gazetting over 11,000 polling stations that the Commission claimed was out of the 3G and 4G networks.
Surely, IEBC's ICT officials must have known that there are some areas where network is weak or totally lacking and should have made provision for alternative transmission. It cannot have dawned on IEBC's ICT officials 2 days to the elections that it could not access network in some areas.
It's disobedience to the court order that the petitioner be granted a read-only access with a copy option coming back to haunt the electoral body.
Had the court's order been complied with, it would have unraveled the mysterious puzzle surrounding Forms 34A. Regrettably, according to the information made available to the court by its appointed experts, the first respondent only allowed a read-only access to this information without the option to copy in soft version only 2 hours to the closure of the court proceedings, which never fully happened anyway.
IEBC was found as to have failed to give a satisfactory response to the extra number of voters who had voted for the position of president. The judges, however, disagreed with the petitioner that President Uhuru Kenyatta had participated in voter bribery and used state resources to propel his re-election campaigns.
If the mere act of canvassing in favor of one candidate as against another were to amount to undue influence, the very process of democratic election shall have been stifled, because the right to canvass support for a candidate is as much important as the right to vote for a candidate of one's choice. Therefore, in order that the offense of undue influence can be said to have been made out within the meaning of Section 171C of the Penal Code, something more than the mere act of canvassing for a candidate must be shown to have been done by the offender.
Irregularities ranging from the lack of security features, serial numbers on the result declaration forms, as well as the availing of carbon copies of result declaration forms by the IEBC, having also largely contributed to the annulling of a presidential election.
Therefore, whether it be about numbers, whether it be about laws, whether it be about processes, an election must at the end of the day be a true reflection of the will of the people as decreed by the Constitution through its hallowed principles of transparency, credibility, verifiability, accountability, accuracy, and efficiency.
And as the IEBC prepares to conduct a fresh presidential poll in compliance with the orders of the court, the judges ordered the Commission to put up a complementary system, but want that the system be only deployed when the electronic system totally fails.
We are therefore satisfied that the petitioners have discharged the legal burden of proof as to squarely shift it to the first and second respondent. We are also of the firm view that having so shifted the burden, not has not in turn been discharged by the first and second respondents as to raise substantial doubt in regard to the petitioner's case.
John Jacob Curia for Channel 1 News.